Aloha, this is Clint Hansen with Maui Real Estate Radio and with Maui Luxury Real Estate at the KAOI Radio Group. You're listening to us at 7 a.m. on all of KAOI's three radio stations throughout Maui County. Today, we have a wonderful guest and our regular co-host, Byron Yap. Byron Yap, please introduce yourself.
Byron Yap here with American Savings Bank on Maui, and
Excellent.
look forward to having this conversation or learning.
Yep. And Professor David Callies, thank you so much for joining us. He is a professor of law at UH and he teaches land use, state and local government, and he has authored a great number of books. Probably one of the greatest ones that pertain to this, of course, is the Preserving Paradise and Why Regulation Doesn't Work. We are here today to talk about, of course, the Minatoya. Professor Callies, would you please introduce yourself?
Sure. I should point out at the outset that I'm emeritus professor right now. I retired from teaching 3 years ago. I'm still active in the practice of law and various committees and consulting and so forth, but I don't teach at the law school any longer and have not for 3 years. I have specialized in land use since graduating from law school shortly before the earth cooled in 1968. I went to England to do a Master of Laws in planning law, and joined a large firm in Chicago that did mostly land use and local government work as well as utilities work. Then I came to Hawaii after several visits on one matter or another in 1978, 77 as a visitor, 78 as a full professor, and then was honored with the Kudo chair about 10 years after that. And so that's what I do. I'm a member of the American College of Real Estate Lawyers, but I'm also fellow of the American Institute of Certified Planners. So I have feet in both camps, and I did a lot of local government representation on the mainland and did some here as well.
Tell us about Hawaii, some of your connections here.
Well, they're a little old right now. I got involved with the city council now about 35, 40 years ago, when they were doing a bunch of conferences on planning for growth management. And we brought in folks from the mainland to discuss different topics having to do with planning for growth management.
Mm-hmm.
And then I did some work for Harold Masumoto, who first was vice president for, I think, administration university, and then was the head of the planning group in the state level under John Y.A.
That's right.
And did some work for them as well. I haven't done much. I did teach state and local government law for 40 some years as well at the university. And so, try to impress on the students the nature of our strange governmental system here, different from the other 50 states, and
very much so.
How it affects
and of course, a long and interesting history too that we could go on an entire show just to talk about. And I actually really want to do that in the future. But one of the pressing concerns that a lot of people have nowadays, because it affects their lives and the state of the economy here, is of course the Minatoya. And the Minatoya is, for all the uneducated out there, is initially an opinion by, I believe, Robert Minatoya, who was a corporation counsel attorney. And initially, properties were planned and for a variety of purposes. And a lot of these oceanfront ones that are A1, A2, R3, and whatnot were initially designed to be vacation rentals, front desks and whatnot. So they were approved and acted as vacation rentals. And then around 1989, people wanted more housing. It was a necessary thing, and there wasn't enough housing being built in conjunction with these vacation rental properties. Kihei is a prime example. 1960s, there's about 300 to 400 people that lived in Kihei, and it grew rapidly with the vacation rental development that came up from that. So everything from there forward was to be that are on those A1 and A2 were not to be vacation rentable. And then in the 90s, Minatoya gave his opinion that no, these properties are grandfathered in. If they were designed and built before 1989, then they should be continued to be vacation rentable. There was a lot of contention with this, but it was the general rule. And then the rule was eventually codified into law. Now, people get confused. There's a rule, there's rules associated with it, and then the list associated with it. The list is not codified. Just because your property is on that list doesn't mean you have the legal right to vacation rent. If you abide by the law, then you do. But of course, that's kind of the minutia. So now, in an effort to create more housing, the county is looking to abolish about a third of all vacation rentals that have been legally operating for over 40 years on the island. And the thought is that these will magically become long-term housing, despite the fact that they aren't really designed for long-term housing. And I've gone over, of course, the economic impact with Paul Brubaker. He's a fantastic state economist and has a long history here in Hawaii. And he pulled data from DBET showing that it would lose approximately 10,000 at a minimum jobs. It could be as high as 15 to 20, but at a minimum 10,000 jobs in an 84,000 workforce. And today I wanted to kind of discuss with Professor Callies the likelihood that this could go through, the process of this going through, and if it interferes with any kind of constitutional, state, or county rules, how this happens. So please tell us what your thoughts are on the rule in general.
Well, the rule, of course, once it's effective, does not take place for 6 months to a year anyway on different parts of Maui.
Correct.
So it's probably not easily challengeable. It could be challenged on its face, I suppose, but that's a difficult thing to do until it's actually affecting property or affecting a lender or affecting someone who can show that he, she, or it are damaged by this. But when it comes to litigation, there are a couple of principal areas that are of concern and will be triggered, I'm sure, by trying to figure out what works and what doesn't. The first is the non-conforming nature of all of the properties that will not be able to be used as they have been used for, if as you say, for 40 years, some for a short term, whatever. There are two kinds of nonconformities, use and building. This is a non-conforming use, not a building. In other words, it's possible to have a building that violates certain bulk restrictions that have been put in, and so it's non-conforming and has to come down in a certain period of time if the government tries to do that. But in either case, what government should try to do, first of all, has to establish why it is that the use is no longer appropriate where it is. And this gets into the public use, public purpose, what is it that government's trying to accomplish? And as you state, Clint, it appears to be the government is trying to ease a massive housing crisis, not only in the state, but also mainly on Maui, with respect to the Maui implementation of what the counties can now do with respect to short-term rentals. And by the way, it's certainly possible. The state can always devolve that power back to the counties, although they have the original power to do that. They can do that whenever they want. So if that's true, then you have the situation. If the county can make an appropriate case for why it's a public purpose, public use, housing shortage crisis, and so on and so forth, then it becomes an issue of whether and to the extent it affects property rights, private property rights. And of course it does. If I've been using my unit in a multi-story building for a vacation rental for a period of time, which is legal for X number of years, and that's the requirement. The private property owner has to show that the use was commenced legally at some point in order to get non-conforming status. And so it becomes a nonconformity, it becomes a nonconforming use, and government generally has the power, though we don't have much litigation in Hawaii, but generally has the power to eliminate that use at some point. And the big issue is, what do you mean by some point? It's almost certainly true that unless you can show that the use is a nuisance, and I don't think you can make a case easily that vacation rentals, they may have been operated in some cases in an unfortunate way, but as a use per se, it's not a nuisance. It's not a junkyard. It's not the favorite in the old language. It's not a house of prostitution. It's not a gambling den. All these things are nuisances which government can eliminate very quickly. But if it's not a nuisance, then the general rule is you got to give the property owner a certain length of time in which to change the operation and do something else. And so that's called the amortization period. It is, as one of my colleagues points out, it really doesn't have anything to do with it. Amortization, as a banker would understand it. And I apologize for that, Byron.
But it basically is the impacted value over time is when you say amortized, right? Like they bought it for vacation rental. If they sell it and it can't be vacation rental, that's one thing that does impact value, but it's really the use value that they have from it over their ownership, right?
That's correct. And the times vary. I mean, the standard case on the subject comes out of the Supreme Court of California decades ago, in which there was a zoning out or eliminating of the use of a plumbing business in a residential zone. And it was a residential house. So the court said, well, you can still make use of it, just like you can make use of the various units that might be impacted by a Maui ordinance. You can still use them for residential purposes. You can use them for long-term rentals. It's still usable. You just can't make use of it as a short-term rental. So then the issue is, so what's appropriate? I think we established that terminating it immediately probably would not work. So what's a good time? In the Gage case, the county of Los Angeles gave the landowner that had the plumbing business 5 years. And the court said, that's fine, that'll work. That's good, but did not give any indication of, well, what if it was 3? What if it was 1? I think it's fair to say there's going to be a challenge, as I read the ordinance, of eliminating these uses in 6 months or a year, depending upon where it is in Maui, if I read it correctly. That's really short.
Yeah. By the time it's enacted, we're talking less than 6 months.
So it will depend on the extent to which I suppose the county can make the case that it's really an important thing to do. But the court usually in the past has not dealt with the term of, well, it's an emergency. It's really whether the use is nuisance-like. And the more nuisance-like it is, the easier it is to amortize it quickly. The less nuisance-like it is, the harder it is to amortize it quickly, but because the courts will balance the effect on the user's property rights. And so this becomes an issue in enforcement. So I think probably the biggest issue is going to be this nonconformity issue and how long the landowner has or the unit owner has to terminate before termination. And I'd be surprised if the court didn't say, well, 6 months to a year is given what's going on around other parts of the country. There are a lot of cases are old. Some of them are not necessarily.
It's just an untenable time period, basically.
It's short. It's very short for amortization period. It comes close to immediate termination. And in most mainland cases, if it's like 6 months to a year, there are a number of cases that have held that that's too short.
Very, very short. So
and then the other issue is vested rights, and that relates to it, but we can get into that at some other point.
Let's kind of change gears a little bit. And one thing I want to talk about, of course, is pertaining to the law. But one of the things I'm a fan of is some of your writings. And you wrote a book, and actually a first and second edition, Preserving Paradise: Why Regulation Won't Work. So if you could start and talk about why you initially wrote it, the change to the second division, and then how this might pertain to the elimination of such grandfathering.
Well, Preserving Paradise sort of came in the middle of the 2 editions of Regulating Paradise. We never did do another Preserving Paradise, but we did do Regulating.
Oh, yes, sorry, Regulating.
That's okay, no worries. That was done twice.
Yes.
The one 10 years after. The main thrust of why regulation doesn't work is that it doesn't really encourage anything. If anything, it just puts brakes on whatever one can do. So the basic thrust of the book is, it's not a great way to undertake, you know, positive planning for growth and management. And so that's it in a nutshell.
Hmm. And of course, uh, as that goes, and I mean, to me, the way that applies to it is you've seen this jump in building from, the 1960s when they decide to work towards vacation rental properties all the way up until, the 90s. And then from there forward, it was like everything changed at that point for Maui County. And you saw a great reduction in the amount of housing get built, and of course, almost complete halting of regular TVRs that are owned by people. So to me, I think there seems to be like a correlation, parallel lines associated with, because additional housing didn't get built at the same pace at which it had been in the past compared to the demand that's needed for it. I mean, the demand just grew and grew over the decades to now we're at like almost a 10,000 plus home shortfall. So is that kind of, even though the inability to build vacation rentals is not related to housing specifically, but still we see that parallel nature of a lack of building overall. Is there, do you notice that in there? Like, is there a reason for that, or is it
Well,
just a random connection that I'm making that isn't there?
one of the issues that we tried to deal with in preserving paradise, why regulation doesn't work, is that whereas almost every regulation that's imposed has some sort of public purpose behind it, whether or not it's a good one, we could debate. But the regulations, one at a time, generally were all well-intentioned. When you put the package together, including our multiplicity of plans, which in all four of the counties have the force of law. They're not just, documents that you kind of look at and decide where things go. They have the force of law. All of in Honolulu, the development plans. I'm not sure, can't remember exactly what they're called in Maui, but I should be able to come to maybe community plans or something of that sort. But they have the force of law. The problem is that we have a plethora of regulations and we don't take any away. Um, there were certainly some other factors involved, but Koa Ridge and Ho'opili are good examples in Honolulu. 20 years plus to get a spade in the ground from the inception of the regulating process. We overregulate. We overregulate by a long shot. You can see where development is taking place quickly, whether or not you think it's a good idea. On Oahu, for example, we're looking at Kaka'ako, which is run by a state agency, controlled by a development controlled by a big plan. But if you fit the plan, you get a building permit. You can move within 18 months to 2 years from the time you conceptualize your development and start digging. Yeah, I know one developer that actually did that. It's going to be years, if not decades, if you're outside that special development district controlled by the Hawaii Community Development Authority. So why is development going fast in Kaka'ako? Because you don't need to deal with city and county regulations.
Yep.
And of course you have the land zoned urban by the state level. But it's a long process if you're starting with greenfield areas in the ag zone before you can finally get a permit to do anything, even when it's in the urban growth boundary, if it's in the agricultural area. So I circling back, it's an issue whether this bill, if it becomes an ordinance implementing the state passing of control to the counties, is going to really affect what it's supposed to do, which one understands is to eliminate or at least help out with the housing crisis. I mean, we all agree we have one, but you just look at the figures on Maui, thousands of units over a period of a few years, trickling down to a few hundred over the next few years. It's just not being built. And there's a limit. Look what happened when the city council 10, 15 years ago in its wisdom decided to put a 50% low-income housing requirement.
Nothing got done.
Nothing happened because you cannot make it work when every third unit has to be affordable and there is no state subsidy for that affordability. It just doesn't pencil out. Otherwise, you're building houses that nobody can afford to build on your two market units. So now I'm practicing economics. So I'll have to apologize to Paul.
Paul's going to call you up. He's going to be very mad.
I'm sure he will. He probably will send me something. So it's again, the thrust of why regulation wouldn't work is that it cramps the construction process. It makes it very difficult for something to pencil out. And so
Yeah, and I mean we are seeing an improvement for sure associated with the reduction down to 25%. But what I'm seeing instead of more building of affordable housing, which we need 10,000, I'm instead seeing them lower the number of homes that they're building in the most important, like not most important, in a very important demographic, the median area, and the density is shrinking and it's becoming larger, units so that they can sell them for more money, so that they can build fewer of these affordable ones that they're going to be losing money on. So, to me, it seems like there needs to be more subsidy associated with, like putting money into other areas like Nahalio, Maui, which is a community land trust, or putting in massive infrastructure plans and actually having an attack like you're saying, Ka'ako. But without that major focused effort to build a new town or create a centralized housing system where there's transportation to the places that people go and work, you're just not going to see enough affordable housing. Now, my question there is there any means for us to deregulate, or is it just too difficult of a process to actually do that the way that our system is, or has what the state has done now made it an option?
I don't what the state has done, as near as I can tell, is sort of, content neutral, if you will. I mean, I don't think it helps or hinders either way. It's the process is very simple. It's a matter of the political will and who's going to do it. You can clearly fast tracking works in every area. The Hawaii Community Development Authority has authority. It's a one or two step process, and that's the point.
Well, I've seen fast tracked developments get shot down many times though as a result of NIMBY. So
yeah, well, it takes a certain amount of I suppose intestinal fortitude to go forward when NIMBY, not in my backyard folks come out. It's certainly happening not only in Hawaii, but I'm sure all over the country on this notion that you can suddenly convert single family zoning by abolishing single family zoning, you can encourage, lots of units.
density.
In fact, not that many units get created and not nearly enough to deal with the shortage. And if you simply allow a lot to be subdivided, you have two expensive houses on it rather than one. And in fact, if they're new, each of them might be more expensive than the house that was on it in the first place. So I'm not I don't, it's fine if folks want to do that. I do sort of bristle at the term, let's abolish zoning. Actually, most folks, if they really looked at it, would be appalled at having, commercial uses, high density smack in the middle of the neighborhoods, and that's what zoning prohibits. There are lots of things zoning does that's very good. The attack is on the single family detached zone.
Yeah.
And
well, let's just say instead of getting rid of zoning altogether, what if you change it so there wasn't, Euclidean zoning? So instead, make it more that you could build housing anywhere, whether that's agricultural, commercial, residential, industrial, like make housing a right as opposed where people can build as opposed to constantly asking permission.
Well, certainly that would help. In Hawaii, of course, you want to carve out the conservation district. I don't think anybody is going to start
100%.
commenting on that. But since, nearly 50% of the land in the state is classified ag, and the kinds of houses that are permitted of right are so-called ag subdivisions, which are large lot,
That's for rich people.
can be. That's the problem. I mean,
That's
I
not what it's supposed to be for, but
No, no. Well, the issue is how do you prevent that from happening and still permit folks to farm on small patches like coffee farmers? And I have no good answer for that. It's the Land Use Commission has been wrestling for a way of doing that for decades. How do you permit one without encouraging the other? We probably don't need a whole lot of so-called fake farms that go for well into seven figures, but we
Mhm.
don't affect the local folks that are a family-oriented enterprise on a piece of agricultural land and do
Mhm.
want to go forward. But sure, it would certainly make a certain amount of sense, depending upon the quality of the agricultural land, to permit that building. But where it usually comes a cropper is infrastructure. I mean, agricultural land is not heavily infrastructured to use
Precisely.
it, to make that into a verb. And that's become an issue. Look at the problems that Hawaii Homelands and the Hawaii Homelands Commission has had trying to get
Correct.
people on lots. You can get them on lots, but there's no water and sewer
Yep.
and no electrical connection. And I, take my
Well,
hat off for what it's worth.
regulation, you have the West Maui Water Commission, which was the first of its kind. And the initial idea is that it was, I believe, voted in by the people, and it was sold as a means of preventing foreign entities from purchasing our water and stealing it, and I guess shipping it off to China, which was obviously not the case. But we did have, Mahipono come in, which is a Canadian-owned company, and they're using local water in order to farm the land. So, and of course, there's historical issues associated with that. But when you create, you know, West Maui Water Commission and somebody wants to use the groundwater, even if they have a well that's already in place and they can pull 1 million gallons a day, but they've only been pulling 100,000, they're not able to make that difference now because historically they've only been doing 100,000 unless they get a permission from a committee that is now in place. And the same thing happens for putting in water for a new development or something like that. So how does that kind of regulation come in?
Well, I'm freely admit I'm not an expert on water law. It is certainly you need water in
Yep.
order to develop it, but it's got to be piped in. So it's a community system, or as the EPA describes it, a publicly owned treatment works, that goes through. Um, I it's been an issue. Resources are an issue as well, but it goes back to the initial matter of infrastructure. You
Yeah.
know, uh, the fastest way and the most in a lot of ways the most economical way to create housing is for the state to infrastructure land and turn developers loose on it, or become a contractor and build more stuff like the Mayor Wright homes in Honolulu.
So that's what it comes down to. I mean, I see over and over and over again is that the state has had more of a band-aid approach to our infrastructure, and they have not really issued a bond in order to increase our limited infrastructure so that that is available. Because, we're on an island, Maui. It's smaller than Oahu, similar, weather patterns to Oahu. So it's not that we don't have enough water. It's that we don't have enough transportation and water storage in order to create housing on the island. And it's hard to ask a developer in order to build water infrastructure for their development. So again, nothing gets built. So of course, that's not why we're here to what we're here to discuss
no,
today.
no, that's
I'm
fine.
I would assume that is just a correct assertion that the county does have a constitutional obligation to put in infrastructure, and they've not been doing it.
I'm not sure, quite honestly. I'm not sure it's a constitutional obligation, but that probably has an obligation generally as a local government to provide what it needs for its citizens. Um, if
Yeah, I
you
think it's a constitutional regulatory commitment, but not necessarily a commitment to put in the infrastructure.
that can be an issue, right? And you're talking about state constitution in any event,
Yeah,
so
exactly. State constitution,
something
correct.
issue. Yeah, yeah, yeah,
So,
fair enough.
so coming back to the Minatoya, the uh, it- would you think, I mean, obviously it's hard to come to the point of constitutional taking, right? And it's more after the fact, like how do we determine stripping these property rights? At what point is the line of constitutional taking? Is that something that we determine now, or the damage is done and then in 5 years when a property is worth significantly less and the associations are bankrupt, like how do we figure that out?
Well, again, it's possible to attack the ordinance, the bill once it becomes an ordinance on its face and say, this is what's going to happen. And so we need the whole thing needs to be rethought and struck down as a matter of federal constitutional law. And you're accurate. That's tough to do. It's easier to do it when you can actually say, my property has been adversely affected. And thereby, it's clear this is not going to be a Fifth Amendment eminent domain taking. There's no attempt to take over the property by the government, and there is no accidental taking over the property. What you're seeing here is a substantial reduction in use rights, and this is in fact what regulatory takings are all about. We didn't even have regulatory takings until after the 1920s, but we have them now. And there are two kinds, and they both apply to Maui. There's the taking of what the court called all economically beneficial use in the Lucas case, which I think you mentioned a couple of times, Lucas versus South Carolina Coastal Council. And
Yeah,
we probably don't have that because there is use left. There's a residential use left. And so it would be almost impossible to do that. But in another case, Penn Central Transportation Company versus City of New York, the court articulated a test for partial takings. And so that's probably what one would try to argue in this case as landowners with respect to and the kind of would have to defend against. So there are two parts to that taking, that regulatory taking. One is the effect, the economic effect on the landowner, and in particular, whether it adversely affects their investment-backed expectations.
the 14th Amendment, right?
So, well, that's fifth.
Oh, the
That's
fifth. It's fifth.
that's Fifth Amendment, and so that's a regulatory taking without compensation. It has in the past not been easy to prove and hard to get into federal court. Now it's easy to get into federal court thanks to a recent decision by the U.S. Supreme Court. You no longer have to go to the state court first and see what the state court says and then go back to federal court. You can go right to federal court. In this state, at least 5 years ago, we got a new state Supreme Court, so who knows? But the federal courts here were more sensitive to landowners' issues and less inclined to rule regularly for the government than the state court. The state Supreme Court tended to be pretty regulatory oriented and not that careful of individual property rights when the issue came up. And now we have relatively three new justices. So there's a five justice Supreme Court. Could change a lot. I don't. It's hard to say until a case gets before it, but it is difficult still to successfully mount a regulatory taking challenge. You have to show that your investment-backed expectations have been frustrated, and you have to prove that the economic effect on you is pretty serious. You maybe that some of the landowners or group of owners of the units can prove it.
It
And if
seems
they
a pretty
can,
straightforward argument, but obviously going to court and proving your argument is different from making it. But I mean, these properties have loans based off of income, and now they're not going to be able to make that income. So it's pretty straightforward. And then if they're not able to make those payments as a result of not being able to vacation rent, I mean, it's not, there's never such a thing as open and shut case, but it's an argument to make for sure.
It can. And you mentioned the 14th Amendment, which has another piece to it, which is very useful. The 14th Amendment prevents aside from applying the Fifth Amendment to the states, which it's often cited for, it also says that you can't take private property without due process of law. And there's two branches of that, substantive and procedural. I don't know enough about the processes involved with respect to the Minatoya. It's complex. The Minatoya rule, the Minatoya ordinance, and the exceptions and so forth. But I suppose one could take a look at the process and say, you violated my procedural rights. That wasn't done properly. Thus, for example, if one were to be denied a coastal zone management permit without a hearing, that would be a violation of one's procedural due process rights. But the substantive ones, which are difficult to show for a variety of reasons, has one piece to it that might be very important in this case. And an ordinance or a regulation attacked on Fourth Amendment grounds can be attacked on the grounds that it does not substantially advance a legitimate state interest, i.e., if the interest is in these cases to provide a lot of low-income housing, and it doesn't, then it falls or having failed to substantially advance a legitimate state interest.
That's a good point.
So that makes the 14th Amendment at least something that the county should probably be prepared to defend against, because you're going to have to show that this helps the housing crisis, and by a lot, not by a trickle. So this used to be a part of the Fifth Amendment takings, but in a Hawaii case, it got to the U.S. Supreme Court, Engel versus Chevron. The Supreme Court, in a rare instance, says, our bad, we screwed up. We should never have had substantially advances as part of the Fifth Amendment case. It's a 14th Amendment case. And by the way, you guys didn't claim anything under the 14th Amendment, so you lose. But if they had, it's an interesting question. That had to do with service stations and whether what a government agency was doing really did reduce competition and lower prices. In this case, the county would have to show that the regulation contributes to solving the housing crisis that it's aiming at, and it does so in a substantial fashion. Substantially advances the legitimate state interest, not just a few. So it's a prong that we don't think about very often, but it's certainly a legal issue that's likely to come up.
Do you think, I've got a question. Do you think that there's going to be individual lawsuits potentially, or, class action, if this passes because it's affecting so many people? What were your thoughts?
Yeah, I'm not a torts person that could tell you what amounts to a class action, but if I can make that into lay terms, do I think a lot of people are going to get together to attack it? The answer is yes. I can't believe that individuals are going to have what it takes these days to mount a challenge legally. But if several hundred band together, then they can probably afford to mount such a challenge.
It would likely be several thousand. There's individual complexes that are already preemptively coming together to talk to attorneys about challenging it. Obviously, I believe it's far too soon to do something like that, because historically the attack on the Minatoya has happened many times before, and it never seemed to accomplish the goals necessary that they're looking for, like increasing housing, because affordable housing, more importantly, because these are aging complexes with, cast iron pipes that need repiping, multi-million-dollar projects, seawall erosion, initial design, is it going to have enough parking? All these kinds of issues that are, in contradiction and wouldn't create affordable housing in the first place. So, but how do you see it? What's the end goal here? Do you think that would even get to that point, or do you think that they're going to evaluate it and be like, this doesn't work?
Well, there's increasing evidence, and I think Paul Brubaker cited some, and I've seen in the newspapers, that ending something like, well, two answers, I suppose. In the short term, there's no question that what the governor did in his emergency proclamation by requiring folks to open their houses that are short-term rentals to folks who need housing because they've been displaced on Maui, that worked. And there was not much litigation, because the Constitution says there can't be a taking without compensation. And as I understand it, the governor was offering thousands of dollars per month to take these folks.
Yep.
And so on a very short-term basis, it works. Okay.
It was a lot of carrot, not a lot of stick.
Yeah. And it's an emergency proclamation. You got to get people housed. Going forward in the long term, I just I just have some real doubts that um, phasing out short-term rentals is going to end up solving even a middle-class housing problem, let alone one that has to do with folks who are below the median income and are needing affordable housing. I just cannot see that the numbers work out, and I don't see anything. I certainly haven't made a big study of it, but I don't see anything in the news media or anywhere else it indicates that that works long term. It's like set asides, even at the 25% level, to get 1,000 units of low income units, you have to build 3,000, okay, or 4,000, and
Yeah.
then 25% of them get in there. When has any county come anywhere near 4,000 units in the last 20 years in Hawaii? And the answer is zero. When have we even come to 2,000? So it
Less than
helps.
500 every year.
Someone like Stanford Cars uses a sharp pencil, gathers in all the requirements from other developers, and builds in Kakaako, notice, a 220 or so unit building in 2 years, largely rental, if I recall correctly, for people of modest to lower economic means. That works, but that was 200 and some units. Yeah, okay,
In
that's
a
nice.
10 times
200
population of
units,
Maui.
and we need thousands a year in order to solve this problem. The last figure I saw was that over the next 3 or 4 or 5 years, we need to build 50,000 units. This is not going to come from the private sector, and it's not going to work by an ordinance that abolishes the Minatoya rule. It's I don't see the connection. I don't think it's likely. If we're looking at stuff that worked before, 10, 15, 20 years ago, uh, under the Waihee administration, there were these Weinberg villages that he created or had built
Yeah,
on Oahu. And 25, 30 units, stick built on state land, okay? And infrastructure was there. And they were not fabulous. They were, I think, one bedroom, living room, dining room combination, small shower, but they cost between $20,000 and $30,000 each to put up.
Yep.
And there were 4 or 5 such villages. I don't know what's happened to them, but that's certainly an economic way to build a lot of units quickly. The other way is what the governor did with respect to state property near Queens Hospital when there was a 10 or 15 unit set of buildings quickly put up for homeless people who had been served by Queens, but were beyond staying in Queens. So they stayed there. You notice in both cases, the government provides the land, the government provides the infrastructure, and then hires a contractor to build the units. And the same thing could be done with respect to small units on a large scale. In medium term on Maui, that would be, I would think, extremely helpful. So would manufactured housing, so-called mobile homes in great numbers.
Well, and I have a story about mobile homes specifically. I had somebody reach out to me that manages a multitude of uh, basically mobile homes throughout the United States. And he is definitely the foremost expert I've ever talked to, but he has extensive hands-on knowledge for creating housing in a variety of different states of that nature for mobile homes. And we're not just talking pre-manufactured double wides, we're actually talking about real regular trailers associated with it. So he was willing to put up a project that he was willing to lose a little bit of money to break even. And the depreciation and infrastructure costs would, of $50 million means he would need it for a minimum of an 8-year project. So the mobile homes renting at a modest, $1,200 to $1,800 per trailer, and that could be used for disaster relief workers or,
Sure.
locally housed people, something along those lines. Um, he would need it for about 8 years. He would prefer 10 to 12 years because then he could make a little bit of money on top of it. And first of all, the county said absolutely not. The only way you would be able to build something like that, which there's literally no allowable regulation for it, is that if you individually sprinkled every single building, which of course is cost prohibitive, and not, and they're metal structures, too. And normally, it's the design of the complex itself that prevents fire.
Sure.
But they're not willing to take that into account at all, the fire regulations. And then in addition to that, they were only willing to give a dispensation to building laws for 2 years. And we're pretty much, at a year now, and we aren't even scratching the surface on the necessary emergency housing for whether it's workers or displaced people at all.
Right.
So again, it's these regulations that get in the way of having a substantial impact on any level or any type of housing, whether that's emergency based and or mobile home based. And that's the problem that we're seeing over and over again, is that the county is trying to fix a problem, but they're just making it worse.
Yeah, well, as before said, I mean, in a way, they have at least two, if not three problems. Immediate housing, which is pretty much tailing off right now for the victims. Intermediate housing, which may be from anywhere from 1 to 4 years, while Lahaina rebuilds in some fashion. And then what happens permanently? What kind of housing is going to be available? Right now, I think the governor is for whom I have the greatest respect, is working very hard, and I think actually so is the mayor, to try and cut through the tape and get something up. But we need to get the stuff up in 6 months to a year, and it needs to be good enough to last 3 to 5 years. That's kind of what we need to do, and we need hundreds and hundreds of units like that. Now, everybody,
Thousands and thousands.
well, thousands of permanent housing.
Yeah, thousands of permanent.
Let's say a couple of thousand semi-permanent. Taking state land and putting several hundred units on it is that's infrastructure, or provide the infrastructure, is the fastest and most economic way to do it. And as one of my colleagues from the mainland used to say, and he's obviously not original with him, there ain't no such thing as a free lunch. So someone has got to pay. And if you put it on the development community, it's going to be the low-income housing requirements all over again. Nobody's going to build because they can't make money.
Well, that was the thing that I was very surprised, because this guy that came in was willing to lose money. It was just a question of how much money was he going to have to lose. And basically, they wanted him to lose 95% of his money. And, and he wasn't going to do it.
And I get it. The construction industry is not wild about not having stick-built housing. They don't like manufactured housing or modular housing coming in. But at some point, especially now that we have the disaster that happened in Lahaina, somebody's going to have to do it. I mean, people ask me, and I'm going a little bit off message here, but a couple of people said, "Well, what would you do in order to rebuild fast?" And I'm sure I made a huge number of enemies by saying I would turn it over to the Hawaii Community Development Authority. It's a state agency. They have a good track record. People don't necessarily like what's gone up in Kaka'ako, but they have a huge track record of getting stuff up fast. And let's have 6 months worth of hearings. People agree, but have to be bound by the majority in the last instance of what the plan's going to look like, and start rebuilding Maui. Start rebuilding Lahaina. The chances of Front Street staying where it is somewhere between 0 and 0. It's too close to the coast and what's happening in global warming. I'm not sure you could armor enough of the bay to make that work. But one could start, if one has a state agency with the power of eminent domain to condemn holdouts, and just start building. That's the long term. But the short term, the state still has to do the equivalent of Weinberg villages, or what the governor did on state land opposite Queens. Get units up obviously can be done. He did it in what, 3 months or less than that?
Yeah, it was
You
very
can do
impressive.
it, and local folks can do the building, but it has to be.
Hawaii too. They have an excellent, history associated with the coming back after the hurricane. I mean, they were able to build back their housing very quickly. I mean,
Very
there's not
quick.
just national, there's local examples of how to get this done. And they don't
Exactly.
seem to be taking the precedent and running with it, you know?
Exactly. Which, to circle back to our subject, I don't see a path forward that abolishing the Minatoya rule and making all these non-conforming is going to contribute much to the supply of low to moderate income housing, let
And
alone
that's
housing.
who is it to make that argument? I mean, isn't it that this county would have to before passing this law would have to show that it actually substantially increased housing? Like, or do they just pass it and see what happens?
Well, my guess is they'll pass it and see what happens because, short-term rentals are an easy target, right? You got people coming in that are not from
Yeah, they're
here.
not voting.
And some of the people who are investing in the housing are not necessarily, although I think a large number of them are local, some of them are not. So it's an easy target. The county is not going to be responsible until somebody sues and say, okay, where's your,
After damages.
where's your purpose? Or under the 14th Amendment, show me how this is substantially advancing the legitimate state purpose. Housing is legitimate state purpose, affordable housing, but I don't see the substantially advancing.
Yeah.
I freely admit I haven't seen the numbers, but I'm betting that Paul Brubaker has numbers that show that it's not going to work.
Yeah, I mean, in fact, it actually does the exact opposite because these transient vacation rentals do more to subsidize and pay for housing than any other property class on the island. In the last 3 years, it generated nearly $40 million to go to the Affordable Housing Fund. And of course, you start building that fund from these various property types, it's a perfect opportunity to issue a bond and use those income streams to pay for that bond and put in infrastructure specific purpose built for affordable housing. So, and then in addition to that, once those properties get built, you get tax revenues from that to pay for that bond even further. And I mean, to me, it's so obscenely obvious to use obvious economic mechanisms to subsidize and perform the tasks that is the obligation for the county and state. But instead, they want to take from one group of people to give to another, which to me seems to violate, a variety of constitutional rights.
Well, there's certainly some issues in that regard. I go back to what seems to work. If maybe you've already had him on, but it would be very interesting to see. It's not really apples and oranges; it's a variety of apples. But to see what Kelly Watson has to say about how
Kelly
he's
Watson.
planning on going forward with Hawaiian homelands. I mean, he's got a pile of money, and from what I can see, he's looking at long-term, using it to get some long-term housing up by putting it into
Yeah,
infrastructure.
let's get the Hawaiians back in Hawaii. That's for sure. That's
And
gotta be a
he's
target.
good at it. I mean, he's done this before. I can't believe he at his he's not an old man, but I'm surprised that he decided to go back into the Hawaiian Housing Commission chair after having had it years ago
Mhm.
under the old system. But he's got a lot of money. I think he's got almost $1 billion now. If you look at the other amount accumulated, there is no reason why that model could not work for low-income housing generally in any county.
Yep.
It's a question of how he's financing and putting it together. I don't think that the fact that it's the Hawaiian Homes Commission gives him any particular financial advantage. He's still got to figure out how to put housing on infrastructured land,
Yep.
and he's obviously got a plan to do it.
So let's go and change gears a little bit. I mean, we're talking about more the state regulatory constitutional rights on the Minatoya, but we did kind of trail off many times about actual solutions for creating housing. So one of the things I'd like to see is the successes of other states, because to me, the reason that we don't have housing is because it's such an incremental and difficult process to build something, even with the existing rules. If you want to permit things, it takes you many cases years. And we're not even just talking about entitlement. So we're just avoiding entitlement completely, even though that is 15 to 25 years to entitle a project
It
between
can be,
infrastructure and all that.
can be.
Let's just talk about properties that are already entitled. You just want to build a normal house on your land. I'm seeing many cases throughout the US where, there's like one county of 90,000 people that has a permitting office of 17 people, and they're able to get permits in less than a 3-week period. So why is it that we have such an ostracized and difficult process here, on our island and all the islands, as opposed to relying on licensed individuals to just file the paperwork, as opposed to having Papa Bear come and check on things?
Well, I don't know that that is the process generally. My experience, again, as you're probably gathering, is mostly on Oahu, and certainly
Yeah.
the Department of Planning and Permitting has had some interesting challenges over the last few years. I understand that the current director is moving in that direction, to expedite building permits. Building permits should be issued in a matter of weeks, not a matter of months or years, because a
And it is years.
building permit. If you have all of your entitlements, which is an interesting phrase anyway, the current Supreme Court does not regard building a house on a single family lot as something you need to get into. Their position is you are already entitled to do that, and government has to show why your regulation is preventing it. We have sort of the opposite viewpoint in Hawaii. You have to prove, how you can get what makes it possible for you to use your land in the way you want to use it. You have to ask our permission.
Wow. Wow.
Either
That's tough.
that's been true since I came here 45 some years ago. So we do have a different view, and we don't have a whole lot of cases that affect that view one way or the other. It's certainly not the way the federal courts have looked at it. At least this is the U.S. Supreme Court. So the answer, I guess, is that yes, the building permit process should be far more automated. I think that although they have proceeded from good and honestly felt public interest, you have to look at all the litigation by the various groups like the Sierra Club, Life of the Land, Legal Defense Fund, Native Hawaiian Legal Corporation. A lawsuit brings everything to a screeching halt. There are very few developers on the mainland, let alone here, that are willing to proceed while the matter's in litigation. And litigation can take years to finish up. If you start in federal court, you're entitled to appeal to the Ninth Circuit Court of Appeals, which is very regulatory friendly. And that's a 2-year process right there, let alone your litigation in federal court, which may take a couple of years to complete. So that's 4 years right there. The chances of getting review before the U.S. Supreme Court are small, but most, they take 80 to 90 cases out of several thousand cert petitions filed. But who's going to go forward based on a federal circuit court decision while there's a cert petition pending before the U.S. Supreme Court? So add another year. So even under the best of circumstances, if you want to jump in and throw a monkey wrench into a project, you can create a 5-year delay. Easily. It's a permutation of what's going on in the national level right now, and how various cases against our former president are proceeding. They are not very fast because there are so many ways to appeal. But circling back to your question, but yeah, I mean, if building permits came out faster, that would be helpful. But once again, if government were doing the work, to some extent, they either don't need or can get a building permit much faster. And that's expedited permitting. Years ago, a couple of my former partners wrote a book called The Permit Explosion by Dick Babcock and Dwayne Fuhrer and somebody else. And even then, there was a national look at how permitting has delayed construction, and delayed construction raises costs. So there's got to be a way.
Carrying cost is the #1 cost for any property.
There's got to be a way of accelerating it. And it is certainly appalling that once one has one's entitlements, a building permit cannot issue in a few weeks. That is not rocket science. That is not.
Okay. So we're getting towards the end of our show, and I wanted to say, now obviously you can't be any sort of final authority, but I would love your professional opinion. Now, with you think with the Minatoya, what do you think the likelihood of removing this is? I mean, given that it will, and I don't mean like the challenges that it'll face if it's approved. I mean, what do you think the likelihood of it uh, actually getting the ban happening, removing the ban? Like, I mean, sorry, removing the ban. What do you think the likelihood of banning the Minatoya will be? And the points at which people can speak up about why it would be socioeconomically bad for them personally and for the county.
I don't know enough about Maui politics to be able to answer that question. I'm happy to just speculate, given the current situation and given what I see, at least the letters of the editor and testimony. I think you've got enough people to think that it will help, that I would say its chances are better than even.
Yeah.
I mean, it's going
People need to speak up. If they don't want this to go through, they need to show up.
Well,
You know?
folks need to be educated about, is this really going to help? I mean, I think most people think that this is a no-brainer. You know, kick out all the tourists that are taking these houses, and they're going to be available to local people. But you then need to ask two questions. A, is it really going to be available? And B, what's the cost going to be?
Yeah. And to pass this law, they don't need to prove that. They just
No,
need to make the assertion, pass the law, and then if it doesn't work, then they can get sued.
I think that's probably accurate. I don't think that there's any deviousness in what's going on here. I think that's just a fact of political life, and short-term rentals are not that popular except for the people who are in them and the people that own the property anyway. There have been enough miscreants that screw up the process for everybody, that I think that there's a sizable group in the
Yeah.
population that think good opportunity to get rid of these folks. They're not good neighbors. They mess us up. They're making money where we can't, name it.
Yeah.
And so it's going to take I think, a massive education effort to say, look, it ain't going to solve the problem. And it's really not a good idea, because look what it will do to the economy. Look at how much money is coming in. Look at the money that's contributed to the housing fund.
Well, even when you do put those factual comments forward, it still is of whether or not they'll believe you. And that's difficult. To me, I've said this from the beginning, that unless you can have 1 to 2,000 people show up to testify that banning the Minatoya is a bad idea, it's going to get banned. Like, that's the only way I see it.
Yeah.
Unless you can get enough people from Maui to show up saying, if this goes through, we are ruined, then it's going through.
Yeah, I think you're probably right, and I sympathize with that. For what it's worth, I came in to testify over the affordable housing percentage, 25 years ago, and everybody that spoke said the same thing. This is not going to work. Development's going to stop. Nobody can afford a 50% set aside. And we were told that we were development oriented and didn't think of the people, and it was passed. And sure enough, nothing happened.
That's how it goes. I mean, the numbers, that's the problem, is the numbers don't lie. I mean, obviously you can bend the statistics, but I'm out there and I'm posting statistics that if this goes through, it's going to remove at least 10,000 jobs. And that's a very, very conservative number. It'll likely be significantly larger than that. And people just say, "Oh, you're crazy, you're fear mongering." And it's like, no, this is real data. I mean, these are professionals that are stating these opinions. I'm just interviewing, and
Yep.
people really feel that there's a lot of ulterior motive. And at the end of the day, a realtor, if there's a bunch of panic sellers going out there, I'm going to be doing great, because more inventory on the market means more sales, and I'm going to be making more money.
Yep.
And I don't have any short-term management at all. And so I'm not going to lose whatsoever. In fact, if this goes through, I will likely make a lot of money. I still don't want it to go through because it's going to be awful for Maui's economy and people and not attack the root of the problem. We have had a functional system in place for building money to create affordable housing for like only a few years now. And then that system is going to all come crashing down before it was able to build enough capital to actually create housing. It's just the most Maui thing I've ever seen.
Yeah. The neighbor islands often see things differently. That's,
Isn't that the truth?
yep, I think that is.
So, is there anything you would like to say in closing? I was very valuable and I appreciate your time today.
Well, we kind of went off into other areas, I think, but I not really. I mean, I think the legal landscape, I think, is fairly clear. It's going to depend on nonconformities and law, nonconforming use law, which we have very little in Hawaii, and vested rights law, and there we have a lot of case law, and I don't, if the bill goes as it is, and you're talking about almost immediate termination. You know, there's a great article that appeared in the UH Law Review years ago called Arrow in Time. Ken Kupchak wrote it along with, I think, Robert Thomas and maybe Greg Kugel, or maybe one of the people that was an associate. The rest of the authors sort of fade, but it's an excellent summary of what it takes, how nonconformities work, and how vested rights work. And folks that are thinking of suing in that area should probably dig out that article and read it.
All right.
It's pretty important.
Byron, do you have anything you'd like to say specifically in conclusion?
No, I've learned a lot. I mean, I like listening to it. It was good. You know, I think it's a challenging issue. I can, you know, there's both sides of it. And I still go back to the time when Maui, the best time Maui had growth was when this county was involved in building Kahului. I mean, all of Kahului, you know, they were putting out what 3,000 to 5,000 homes a year, and that was county involvement. And I really think that's what needs to be done here in Maui is the involvement by the county.
No doubt. Absolutely.
Yep.
Well, thank you so much. I really appreciate everybody's time. Again, Professor David Callies, you want to reintroduce yourself on our way out?
Yeah, David Callies. I'm Emeritus Kudu Professor of Law, taught property, land use, and local government law for 40-some years at the university, and that's what I still pretty much do for a living.
Awesome.
Nice.
And Mr. Yat.
Byron Yap with American Savings Bank. Good day.
And I'm Clint Hansen with Maui Luxury Real Estate and Maui Real Estate Radio. You can go to mauirealestateradio.com and listen to this and all our radio shows there. And if you're looking for property you can always go to mauirealestate.net, one of the top local resources for real estate on Maui. We have over 40,000 unique visitors to that website every month. And thank you, and we'll see you next week. Aloha.